Thank the gentleman. I yield myself such time as I may consider.
The gentlewoman's recognized.
I'm sorry, Madam Speaker. I rise in opposition to the en bloc amendments.
The gentlewoman's recognized.
Thank you, Madam Speaker. I yield myself such time as I may consume. In America, discriminating in pay based on sex is illegal, as codified in the Equal Pay Act and the Civil Rights Act. Democrats claim H.R. 7 will improve upon these bipartisan laws to create new opportunities for women to fight pay discrimination. What H.R. 7 actually does is create new opportunities for trial lawyers to earn higher paychecks while offering no new protections for pay discrimination in the workplace. Unfortunately, I cannot support any of the Democrat amendments to H.R. 7 because none of them addresses the numerous unworkable and onerous provisions in the bill. I appreciate that Representative Byers' amendment recognizes the very serious problems with H.R. 7 by attempting to place a fig leaf on the expansive government data collection mandate in the bill. However, the Equal Employment Opportunity Commission, EEOC, is still required to implement the draconian data collection scheme in the underlying bill, which is still extremely misguided, expensive, and unnecessary. H.R. 7 requires business owners to submit reams of pay data to the EEOC disaggregated by job category, race, sex, and ethnicity. Moreover, the collection mandate also includes other employment-related data, including hiring, termination, and promotion data, which even the discredited 2016 Obama administration pay data collection scheme did not include. The data collection mandate in H.R. 7 raises several concerns. First, it puts at risk volumes of highly confidential pay data involving millions of individual workers. We all know of the widespread data breaches the federal government has suffered. Second, EEOC will not be able to manage or properly use this data. It has never been explained what exactly the EEOC will do with this data. Madam Speaker, data is not the same as information. Third, this mandate is overly burdensome. Under the Obama administration scheme, the data cells required from business owners when they file an employer information report, EEO-1, with the EEOC expanded from 180 cells to 3,660. Let me say that again. From 180 cells to 3,660. H.R. 7 scheme will add on hundreds, if not thousands, of more data cells. EEOC has estimated with the new reams of pay data added, the collection will cost business owners more than $600 million annually. I doubt that's going to help one single woman in this country. Although this amendment purports to give EEOC more discretion to implement the pay data collection, this data collection mandate should simply be removed from the bill. In any event, discretion cuts both ways, and the Democrat-controlled EEOC may choose to implement a data collection scheme even more expansive. Let me be clear that the Buyer Amendment does not improve the draconian pay data collection mandate in the underlying bill or the other serious flaws in other sections of H.R. 7 we've talked about today. Representative Newman's amendment takes a long-standing reasonable requirement and makes it disruptive and unworkable. First, the amendment requires a workplace notice posting of a partisan special interest bill which fails to address pay discrimination in the workplace. Second, under current law, covered employers must post a notice of equal employment opportunity rights in a conspicuous place at the workplace. Employees who telecommute or otherwise do not have access to the physical notice must be provided an electronic version. Under Representative Newman's amendment, the employer must post electronic copies of a new notice on an internal website to which employees have access. This is unrealistic. H.R. 7 applies to millions of small businesses that do not have websites, much less internal websites for their employees. In keeping with the other impractical provisions in H.R. 7, the amendment adds another onerous requirement on small businesses who will be stuck with the bill. Representative Ocasio-Cortez's amendment would create a new program for the Department of Labor to, I hate to say this word, quote, train, end quote, employers regarding bias in negotiation and other wage-setting practices. The amendment includes a non-exhaustive list of 13 wage-setting practices on which employers allegedly need education. Employers may understandably view this list as 13 new ways for trial lawyers to allege violations of the Equal Pay Act. I'll compliment one aspect of Representative Ocasio-Cortez's amendment. It mentions compensation self-audits. Republicans agree that self-audits can be a useful tool in combating pay discrimination, and we urge support for the Republican substitute amendment, which encourages employers to conduct self-evaluations to identify potentially unlawful pay differences and to take steps to rectify any unlawful pay practices. Unfortunately, H.R. 7 does not encourage these self-evaluations. Representative Williams' amendment reestablishes the Obama-era National Equal Pay Enforcement Task Force. This amendment would establish another politically biased government bureaucracy that includes agencies such as the EOC and the Department of Labor, already tasked with enforcing laws against pay discrimination and ensuring compliance with those laws. Madam Speaker, I reserve the balance of my time.
Gentlewoman from North Carolina reserves